Ladies and gentlemen, welcome back once again to Samuel Adams Returns. Those anti-federalists, they absolutely got it right. And this is Tom Navolis, your host. And today I am so excited because I have Dave Welty with me. And we're going to be talking about his book, which is awesome, is the UnFaithful Guardians. And we're going to talk about it more. I'll bring it up closer. His website and all of that is in the promo. And you can find the links there as well as on YouTube to all that information. So it's going to be really, really exciting to have this conversation with you, Dave. And welcome.
Thanks for having me.
Yeah, delighted. You know, just as a quick note, there's so much stuff that's going on. And what we've seen, especially with what's going on in the courts, we've watched that for a lot of years. You've watched it in particular. Right. I mean, that's what's really drove your book from my perspective. But, man, I mean, just some of the recent stuff is like, wow. I mean, did you ever imagine that?
No. I mean, it's just gone truly from bad to worse.
Yeah.
In perhaps the last 30 years.
Uh-huh.
I mean,
go ahead.
There's really little connection anymore between constitutional law and the Constitution. And the interesting thing is, in law school, they don't teach you the Constitution. True. Surprisingly,
yes,
they teach you constitutional law, and it's just become there's just no connection anymore to any degree.
Yeah, interesting. So as we get into this and we start talking about this a little bit more, Dave, why don't you give us a little bit of your background? I know you're an attorney, but you know, what in the world got you started in wanting to even be an attorney, and then how that progressed for you to you know, through some of your career and everything.
Sure. I am an attorney. I retired from full-time practice about a year ago. I grew up here locally, went to Mayfield High School. I graduated from the business school at Miami University. My dad was a lawyer, and I decided then to also get into the practice of law, and was admitted to Case Western Law School here in Cleveland. Graduated in 1974. My dad and I practiced with another gentleman for about 10 years, and in the mid-'80s, he and I joined a law firm in Cleveland called Walter & Haverfield, about 20 lawyers. At the time, is now probably 50 lawyers. I was the head of their corporate group. My practice was principally corporate law, mergers and acquisitions, estate planning, and then in 2003, I think it was, I joined the law department of an international German company called Linde Gas, and was principally their merger and acquisition lawyer for North and South America until I retired, and also the attorney for their healthcare group. Wow. So my practice really had little to do with the Constitution.
Right.
But I'm going to say, gosh, maybe 10 or 12 years ago, as I was observing what's going on in the country, and starting to come to a conclusion that, you know, some of the things the Supreme Court is deciding just doesn't seem right to me. It doesn't seem to be based upon what little I knew at the time of the meaning of the Constitution. And so I started doing some research and did a lot of reading. The book that really had an impact on me initially was Robert Bork's book, The Tempting of America. And then I read some other materials, but probably the most critical book was a book written by Raoul Berger, who was a professor at Harvard University on the Constitution. And he wrote a book called Government by the Judiciary. And it was published written and published about the time when Roe v. Wade was decided. And while Professor Berger was admittedly a Democrat and a liberal during the Roosevelt administration, Berger also believed that the facts are the facts. And and what he explained to me was just eye-opening in terms of how the Supreme Court now has really become a significant governing body that establishes fundamental social principles for our country instead of just being a court.
Yes. Yeah.
You know, and
yeah. It's kind of interesting because for me, I've been watching some of what Dershowitz has kind of spun around and come around in a lot of that
he
similar
seems to
manner.
have, yeah.
You know, because I mean, he always talks about being a rule of law guy,
Right.
And for a long period of time, he kind of held a little closer to his more liberal, if you would call, not classical liberal, but more that democratic liberal roots. But then over the last 2 years in particular, you're seeing that he's really trying to drive to rule of law.
Right.
So I think that when anyone, starts to take a look at the honest reality and facts and formation of constitutionalism and our Constitution in particular, of all those other processes out there, they look around and they go, oh, wow, this is really interesting. What is the rule of law? How does that apply? And then how do we really apply the Constitution relative to all of these various decisions in that?
Sure.
So that's what really, that lights my fire about your book as well, as we get through it. So what was it so you brought us through some of that and what you were reading, but then what impassioned you from looking at that and saying, wow, I need to write something about this. I mean, to write I know what it's like to write, because I got a couple of books out, and you sit there and you go, you got to be crazy to sit down and try and put all these thoughts to paper that are going to make sense, or you hope they make sense to somebody.
Sure.
Yeah.
Well, I mean, based upon the research I'd done over perhaps a 2 or 3 year period, I actually formed an impromptu class at my church on the Constitution.
Great. Yeah.
And the people seemed to really enjoy it. And one of my students back then said, gosh, you really ought to write a book about this. And I said, oh, I don't think I'm going to do that. But the more I thought about it, I thought, well, maybe that's something I can do. So I did a great deal more research and started down the road of writing the book. And as it stands today, it's actually in its 3rd edition. I've expanded it now twice.
Mm-hmm. It's amazing how that works, isn't it?
Yeah, I
know. We just got this second book out that follows with the seminar, but the thing is, I'm going to it and I'm going, oh man, I need to go back and really hammer home a little bit stronger on the end conclusion, all of that. So it's like, oh boy, here comes a revision somewhere down the road. So I really respect that. Yeah. But and that's what happened for you. You saw some things, you got some counsel, and so that's why you went into that additional revisions?
Yes. I mean, I used it to teach additional classes, if you will, at the church, and then I was invited to teach in an adult education program at Lakeland College locally here. Mm-hmm. People responded to it well. As I was teaching, I would introduce some new subjects, such as presidential power, which was not in the initial book, voting rights, citizenship clause, those sorts of things. And people really took to that, so I added more chapters, if you will, as we went along, and also revised it significantly, particularly in the areas that dealt with what the 39th Congress did immediately after the Civil War. My understanding grew in that, and so I did significant revisions to that so that we could better understand really what was intended by the 14th Amendment in particular. I mean, it's kind of funny to explain how I went about this. I can't tell you the number of evenings where we might be sitting there in my family room and my wife would be watching Dancing with the Stars, and I'd be reading the congressional record of the 39th Congress in 1866. Because it's only when you read those fundamental documents.
That's right.
And you look at the materials of the State Ratification Conventions that ratified it, that you start to understand why did they write and why did they ratify the 14th Amendment? What were the evils that they were trying to deal with? Yes. But today, to suggest that those men in 1866 in the 39th Congress and the northern states principally who ratified it thought that in 1868 the states were voluntarily surrendering their power to regulate or legislate abortion is pure nonsense.
Yes.
There's not a scintilla of evidence
Right.
in the 39th Congress Congressional Record or the state ratification conventions or the newspapers that were explaining it.
Yes.
Not one scintilla of evidence that would suggest that.
So I really want to hammer home on that a little bit in one of the other segments.
Okay.
But I think the core part of what you're saying, and it comes to the whole idea of what you opened up with, is that the Constitution's not taught in law school, let alone in much of university at all. And relative to that, there's many people that sit down and say, well, if I'm going to read something, maybe I'll read the Federalist Papers at most. And they never get into either Madison's notes, or which I know you like Yates as well for Brutus.
Sure.
And so there's a lot there that they don't get into those, once again, the arguments that were more important, as well as then delving into all of the states ratifying conventions. There's so much more that gives intent. So you and I have had the conversation in the past. Can we define intent? Is there a possibility? Well, if we dig into what all happened in those conventions and how did that come through, I think we could get a pretty good idea, don't you?
Yeah, and let me just say a couple things. First of all,
Sure.
When I say that law schools don't teach the Constitution, there's not much time spent, if any, to deal with the historical meaning of it. What they teach is constitutional law, which a lawyer certainly needs to know.
Yes.
It is the law according to the Supreme Court and the Supreme Court's view of what the Constitution means. But to get back to, I think, what you're driving at, it gets to a fundamental argument or discussion, if you will, between legal scholars of what's called originalism and living constitution. And to this day, I don't know what living constitution means. I just don't. It was brought forth when I was in law school in the 1970s, and frankly, has its roots going back to the turn of the 20th century. But the fundamental issue is this. When those men in 1787 wrote the Constitution, it may seem to us today, 200 some years later, that some of the words and phrases are vague or ambiguous. And so the question is, if when we read it today, words and phrases appear to be vague and ambiguous, should we then decide simply to put our own meaning into those words to reach an outcome that we'd like to reach? Or do we have a duty to try and understand what the lawmaker intended when he wrote and adopted the words?
Yes.
And we'll find in almost every case, other than what I call the natural born citizen phrase that deals with the qualification to be president, that these words and phrases were not vague or ambiguous to those men who wrote it. They were very bright men.
Yes.
Many of them were lawyers. They were the best of the best.
Yeah.
But it's only reflected when we study the history
True.
of the time.
And that's what I want to come back with in the next segment as we get into a little bit more detail of those key areas in your book, especially the ones, like you said, the 39th Congress that really energized you as you were writing this. One of the last couple of programs that I did, I went back to the Articles of Confederation, and we're showing where if one takes and goes into that and some of those earlier writings, some of that ambiguity becomes alleviated when you start looking at, this is some of the stuff they were trying to fix, but what was it that they were trying to keep? And how did that then get argued as it went into the states conventions? So I think we're pretty much saying similar, if not almost the same thing, in regards to how you have to look back that there is clarification. So what we're going to do as we come back into the next segment, we're going to continue this discussion with Dave Welty. We're going to continue talking about his book as I try and hold it up here, Unfaithful Guardians. It's really good. You could get it at his website. Is it on Amazon as well?
No.
Okay.
You can get it through my website, and
right.
it's important to note that it's a third edition.
Yeah. All right. Very good. So what I'd like you to do is come on back in this next segment, because as we talk with Dave, like we just said, we're going to get into the meat of the matter here. And as I always say, it's going to help you to become better informed and active in your community as you have this understanding. So come on back when Samuel Adams returns, because you know what? I think those anti-federalists, they absolutely got it right. Ladies and gentlemen, welcome back once again to this second segment of Samuel Adams Returns. Those anti-federalists, they got it right. Here on Liberty Works Radio Network, where liberty does work for you. And as I always remind you, as we're sitting here with Dave Welty, my guest today, and I remind you every week, is that this is a listener-funded program. And ladies and gentlemen, you can take and go on the website and please look at all of the other hosts and hostesses. Look at the daily programming that's there every evening. There's some good stuff, especially in that Maryland market. You guys have you got a tough row to hoe, I'll tell you. And not that we all don't. I mean, we got things going here in Ohio right now in our legislature that are just mind-blowing. But, that's another story that we don't have time to get into today. But the point is that I really would like you to take and go to the website, look at that donate button. Again, you could go to lwrn.net or libertyworksradionetwork.com. And you know what? Help out. It's all about you. It's all about liberty. And with that, we're going to come on back with Dave and talk about his book. I'm having a single-handed hold here on UnFaithful Guardians. And it's interesting because at the break, what we were talking about was, how'd you come up with the title, Dave? I mean, that's interesting.
Yeah, I played with it for a while, but then where it actually comes from, it's a play on words from Alexander Hamilton, who was one of the three authors of the Federalist Papers. And Hamilton, I guess, was chosen to defend this concept of a federal judiciary, which had never been done before. And he was defending the need for it. And there was, of course, concern from the anti-federalists that, the new national government may exceed its powers. Right. And how was that to be prevented? And I'm going to paraphrase it, but he said essentially, don't worry about it. We'll have this Supreme Court, which will be the faithful guardians of the Constitution,
yes,
to keep the national government and the new president within their boundaries.
Yes. And
hence the title, Unfaithful Guardians.
I love it. It's a great play on words, and you really drive it home as you get into the details of the book. So with that and the details of the book, what we were talking about as well is the book's kind of broken up into sections.
Yeah, it's in 3 parts, actually.
Okay.
And the first part is what I call preparation. It's 4 chapters. The first chapter deals with explaining originalism and this concept of the living Constitution, which developed about 100 years ago. But
wow. Boy, that's a wild one. Isn't it?
But when you look at the founders, one after one, it's very clear that they understood and intended that the courts would use originalism in interpreting and applying the Constitution, which is simply, originalism is what I would call a process-oriented outcome. The court goes through a process of understanding what the Constitution meant historically, and then applies that meaning regardless of the outcome that results. Or living Constitution is a results-oriented process. The court has an outcome in mind that they would like to reach, right, and so they're going to write their opinion in a way and pretend that the Constitution means something that it really doesn't.
Right. Yes.
And the classic case is probably Roe v. Wade, but there's been others since. And before.
And there's a number of them that you cover. Right. And so it'll be interesting as we move through because, so finish up a little bit more.
Well, then I have
in that whole first part, so you look at originalism versus
living Constitution. And chapter 2 is a little bit about the history of the convention. You need, again, this book is as much about history as it is the law.
Yes.
But you have to have some basic understanding of what happened as the states revolted from the British monarchy, what happened during the war, how they worked together, the concept of the Articles of Confederation leading into the Constitution, and the different groupings of founders, what was known as the Nationalists initially versus the Federalists, that afterwards became the Federalists and the Anti-Federalists.
Yes.
And one of the commentators said, no, it should have been called The Rats and the Anti-Rats.
That's yeah, it is.
But and then
Yeah.
chapter 3 deals with, lawyers love Latin phrases, but
Yes.
chapter 3 deals with the concept of stare decisis.
Mhm.
And you need to understand that because it really leads to the conclusion that when a judge is dealing with a constitutional issue, it's not for the courts to make up new law as the courts had done historically under what's called a common law concept.
Right.
But rather the courts must focus upon and understand the meaning of words that they may view as vague or ambiguous as it was intended by the writer.
Mm-hmm.
The founders were not stupid men.
Mhm.
They knew.
Yes.
They knew that the country would change. And it was very likely that the Constitution would need to change. They knew that.
Mhm.
That's what supporters of the living Constitution say today. Well, those men are dead and gone. Why are we following what they wrote? But
Right.
the real question is, we all agree the Constitution should change. The issue is who should change it.
Right.
5 unelected lawyers who were educated at Yale and Harvard Law School, or 330 million Americans by amending the Constitution.
Correct.
The founders chose the second way.
Yes, there's a process.
Exactly.
And that's
And we've done it.
And we have. I mean, that's
Right.
why we went from right off the bat, through that whole process of getting to the Bill of Rights. And then right after the Bill of Rights, there was 11 and 12. And then it was a number of years later before we got to 13, 14,
The
and so on.
Reconstruction Amendment, sure.
Right. So, with that whole process, and one of the things that I show in my book is, the 1,000, 1,500 times that various amendments have either gone through from that legislative perspective that never passed, but somebody's always trying to throw in, something and say, hey, let's amend this or let's amend that. And so it becomes interesting that people have, or even the legislature has, but it was ultimately up to the people and how the ratification process worked. But what I want to draw back to on that is that when you look at, then the judges are supposed to take and look at the words, at the law from that perspective. And explain that a little bit more, because I think people really don't get that. They get this thing, what's precedent? How does that fit into what you were just talking about? Precedent versus, taking and studying the context of what the legislature puts forth and then becomes codified versus something that gets moves through the court system and through judicial action. Now it is something that becomes precedent. Can you kind of, because I think you clarify that, somewhat in that section. I know you clarify it throughout, but I think that was your starting point.
Well, we talk about it in chapter 3. It's
Yes.
part of the concept of stare decisis and precedent. And to understand it, you've got to go back into English history, really following the Battle of Hastings and the need for the king's judges to develop a uniform law throughout the realm, where prior to that, different areas of the country and different tribal groups had
Right.
different legal principles. And so as part of that process, there were a number of fundamental issues like property ownership, what sort of rights you have if someone injures you or your property,
Yes.
what's called tort law today, contract law, property law. The king, and then eventually the king's legislature that ultimately developed into a parliament, didn't deal with a lot of those civil issues between people. And so the king's judges developed the law themselves through written opinions. When two people would come before the court and one guy's claiming that another guy damaged his property, the judge didn't know what law to look to because there was
Right.
no legislative laws or king's decrees. So the English judges created it. And once they decided a legal principle, they would write it down in an opinion. And then if 2 years later a similar case comes before the court with a very similar fact pattern, the court would apply the law in a decision that was rendered 2 years ago, that decision being called precedent. Now that only makes sense if there's no law to start with. But if the legislature enacts a law
Yes.
and writes it down, then the obligation of the judge is not to create his own law. The obligation of the judge is to look at the statute and apply that law to the case that's before him. And if the judge believes that any words in that statute are vague or ambiguous, then the judge should look to the records, the historical records, to determine what the legislator intended.
Yes. And we could go on
And-
for days
Yeah,
talking
you-
about that.
Well-
Yeah. So chapter 4 then in this first part, what does that cover?
Well, that's really my own original chapter, quite frankly.
I think that's where you kind of summarize
Yeah, it's
it.
power and rights and federalism.
Yes.
And so many people misuse the word right. I have a right to, health care. I have a right to retirement income. I have a right to free speech. I have a right to carry a gun. But really what a right means is it's an absence of power. What I mean by that is, for example, if you say I have a right to free speech, you're referring to something in the First Amendment. But what the First Amendment says is Congress shall make no law.
Right.
It's just an admission, and Madison wanted to make that clear in the first Congress. It's simply an admission or statement that the 17 enumerated powers that were given to Congress the year before don't include the right to regulate speech.
Right.
And so they said Congress shall make no law. But it doesn't mean that you have the right to go into your employment and say whatever you want to say about your employer and not get fired.
Right. Exactly. Yes.
It's only a limitation upon Congress. And frankly, it's not a limitation upon the states.
Correct.
It says Congress shall make no law.
And we're going to cover more
Okay.
of how that got twisted, as we go into, the next segments. Let's we're getting closer to the end of the segment, so let's start talking about then that second part. What are
Sure.
the components that you have?
Yeah,
in
the title,
second part?
sure. The title of part 2 is what I call expansion. And clearly the founders intended to give, for the states to give the federal government fairly limited and specific powers.
Yes.
Congress was only given 17 powers to create a uniform currency, bankruptcy courts, patent system, a federal judiciary, Army, Navy, that sort of thing.
Right.
And what's happened over the last 230 years is Congress has enacted laws that have no connection to those 17 enumerated powers. And in addition, Congress has spent, as we all know, an enormous amount of money, way beyond the tax revenues. We now have a national debt in excess of $20 trillion.
Yes.
And the question is, what spending power did the founders really intend to give the national government? So
Yes.
the spending power is dealt with in one chapter, the regulatory power in the next chapter, and then I finish it off with a chapter on presidential power.
Yes, I love that. Those were some things. There were some real key notes in there that I was able to extract as well. We walked down similar paths in both of our books, and so that was really excited me when I saw some of the work that you did on that. And to your point, where a lot of people don't pay attention to is around the presidential powers, some of the extraordinary things that have happened, especially with international executive agreements.
Sure.
People have no clue. They talk about, what is an EO, but when they come to what's an international executive agreement, they have no clue of what that is. And so as we're going to come back in the next segment, we'll delve a little bit deeper, and then we'll get into that third segment. And I'm probably going to wrap the second one fast because, again, that's so much information in there. But when we get into your last section,
Yeah, part 3, suppression.
my goodness, that to me that's just like the icing on the whole cake of what we have. Just real quick, we have about 30 seconds for you, and then I got to wrap for 30 seconds on the presidential power. Give me 30 seconds of what you think is the biggest hit on the president's exceeding power.
Executive orders.
Executive orders. Yeah.
I mean, DACA's the prime one.
Right.
That really has no constitutional basis to it.
Right.
The job of the president is to enforce the laws enacted by Congress, not to create his own laws.
That's it.
And executive orders, in so many examples, in effect, do that.
Yes, absolutely. Well, ladies and gentlemen, we're going to come back for that third segment. We have Dave Welty here with his book, Unfaithful Guardians. And I'm telling you, this is a book that goes, all the other ones that I've read out there, this one is really, really good. So when we come back with Samuel Adams returning and those anti-federalists getting it right here on Liberty Works Radio Network, where, ladies and gentlemen, liberty does work for you if you go out and work for it. Ladies and gentlemen, welcome back once again to this last segment of Samuel Adams Returns, those anti-federalists. They absolutely got it right. And again, we're here with Dave Welty. Dave, thanks for being here all this time with us. It's really enjoyable. And his book, Unfaithful Guardians. And I love what you explained in the last segment on how you came up with that play on Hamilton's concept that these guys are going to be watching out for us, the court in particular. So I think that gives us a real jumping point into your last part of the book. And you call it again?
Suppression, part 3.
Where'd you come up with this idea of suppression?
Okay. Well, as I said earlier, part 2 is expansion, which is the national government exercising powers that the states never gave to the national government. The founders believed, and this belief continued up through the Civil War, quite frankly, that 90% of governing should occur at the state level.
Yes.
In so many areas. And the states retained an enormous amount of power to regulate as they chose within their state, and the states could make different decisions on many, many issues.
Where are the states today?
Yeah, I know.
Do we even have any states today?
So suppression deals with the role of the Supreme Court to, piece by piece, remove from the states the power that the people gave their individual states to regulate their society.
Yeah.
I mean, one good example, for example, is the Bill of Rights.
Yes.
Madison promised the Anti-Federalists that first thing he would do with the first Congress, if he had the chance, was to adopt a Bill of Rights, because many of the state constitutions had a Bill of Rights. Okay.
Yes.
So the Bill of Rights was always intended to be a limitation upon federal power. And the Supreme Court made that very clear in Barron versus Baltimore in 1833. It has no application to the states.
Is that not also kind of a clarification component of the preamble to the Bill of Rights? Because people don't realize the Bill of Rights has a preamble.
Yes. No, that's right. And so, for example, the First Amendment says Congress shall make no law. And in the First Amendment, it talks about two aspects of regulating religion, prohibiting Congress from establishing a national church like they had in England, the Church of England, or passing laws that would infringe upon one's right to worship however they chose to worship. But it was never intended to limit the states from doing that. And so, for example, the state of Ohio, if they thought it was a good idea in its public schools to have religious training and to have prayer in public schools, the state of Ohio was free to do so, and it did so for well over 150 years.
Yes.
When the 14th Amendment was enacted and ratified in 1868, litigants raised the issue once again that the Bill of Rights applies to the states, and therefore there's certain things the states cannot do. And most of it dealt with criminal procedure matters, like the Fourth Amendment issues, Fifth Amendment, Sixth Amendment.
Right.
And in case after case, the Supreme Court from 1868 till I think 1925 continued to say that the Bill of Rights does not regulate state legislatures.
Correct.
But for some reason in 1925, the court just flipped and decided, no, that's not the case. We've got it wrong for the last 80 years. They threw precedent out the window, because you had all these Supreme Court cases that said otherwise.
Right.
And the Supreme Court started down the road of imposing the First Amendment and the various criminal procedure amendments upon the states.
Yes.
And in effect, the court was suppressing state power, the power that states had since the beginning to decide issues related to religion, to decide issues related to speech, to decide issues related to how you prosecute a criminal and punishments you can apply to a criminal who's been convicted. And all of that was removed by the states, and the Supreme Court decided we're going to tell all 50 states how to handle those matters.
Right.
And that's suppression.
Yes, yes. And I love the way that you actually walk through a number of, and you move through a whole process in your chapters there into social justice, into this, into that.
Sure.
And one of the things, I don't want to blow out the conclusion for everybody, or one of them, is that, if we did it right, it'd make everybody mad.
Sure.
And I really like the way that you talk about that. If we really look at how to properly apply the 14th, or even make changes to clarify the 14th, that they're people's assumptions and presumptions more than just assumptions would just get blown out of the water if we return to those true constitutional perspectives on it and original intent even for the 14th. So, kind of walk us through a little bit more on some of those other areas.
Sure.
And segments there.
I suppose the case that really started the court down the hill to where it is today is a very sensitive case, Brown versus Board of Education.
Yes.
In 1954, when the Supreme Court decided, Justice Frankfurter in particular, that public schools should no longer be segregated based upon race. Is that the right outcome? Yeah, I think so. It makes no sense to me to separate children in public schools based upon the color of their skin.
Yeah.
Of course, that's the right outcome. But the question really is that outcome based upon the language of the 14th Amendment? And it's interesting because Justice Frankfurter's law clerk, Alexander Bickel, was asked by Frankfurter to do thorough research of the 14th Amendment, the congressional record, so on and so forth. And Bickel came back to Frankfurter with a memo saying, look, there really is no historical basis for the court to make the decision it wants to make.
Right.
As right as that decision may be, there's just no historical basis for it. But the court moved forward and rendered its decision. And yeah, I agree from an outcome standpoint, that's the right one. But that was a decision really to be made by the people on a state-by-state basis as far as the original intent of the 14th Amendment. But carry it forward then into Roe v. Wade in 1973. On that issue, whether or not a state should be able to regulate abortion is one that is even highly contested even today in our society. You have enormous pro-life and pro-choice groups that are still debating that issue. And in effect, what Justice Blackmun did in Roe v. Wade was take away our right to vote on that issue. Right. We're not allowed to vote on it. Yeah, all 50 states have to do it in a certain manner, and it really is a suppression of our democracy. Now, more recently, in the Obergefell case, where the Supreme Court said, by the way, the 14th Amendment means that no state can define marriage as merely between a man and a woman. To do otherwise violates the 14th Amendment. Once again, the court has simply taken away our right to vote on the issue, as though we don't have the ability to make that sort of a decision.
Yes.
But to suggest that in 1868, when the state of Ohio ratified the 14th Amendment, which was written by John Bingham, by the way, congressman out of Ohio, that they knew that when they ratified it, they were giving up their right to define marriage, is absurd.
Yeah,
I mean, there's just no shred of evidence to that point.
Not whatsoever.
So it's just the court, once again, wanting to reach an outcome, and 5 justices pretending that the 14th Amendment means something that it truly just doesn't.
Sure. And I think it becomes, from even out of the first segment when we talk about, we were talking about education for lawyers. But when it becomes extensible into education for everyone, most of the founders intended that education wouldn't just produce citizens that would be going plugging in somewhere for work, but they would actually be citizens,
Right.
and that they would have a clear understanding of the functionality of the Constitution so that they could make the decisions as to, all right, do we take and we look at this from that legislative perspective, and how do we codify it in a way that's meaningful for us and our community and our state? And I think that was one of the predictive elements of the Anti-Federalists, was that, well, what happens if by whatever mechanism, the court, the legislature, Congress, or some presidential executive order insanities, next thing we have is exactly what you're talking about, that suppression. And the people don't know how to discern that in a way that is meaningful to reject it. Because as we come together in community, so I go into my sociology background on this aspect of it and say, you know what, First Amendment, I could go scream in my backyard as long as I want to, but if the neighbor all of a sudden complains, guess what? Or, you know what, I never had a neighbor before, now I do. Well, wait a minute, now I have to, become part of a society, develop a culture, and we have to come together on some kind of a framework. And that's fundamentally what we went through in this whole process. And in taking that process then is that the states, you know what, if you don't like what's happening in Ohio, go move to New York. Yeah.
Oh, they fully expected that states would make separate decisions on a number of these issues,
right,
including, for example, abortion or defining marriage. California may decide one way, the people of Texas another way,
right,
and that was the intent of the founders.
Absolutely.
That governing was to occur on a state-by-state basis, and from the very beginning, the states made different choices. Now, people will say, well, wait a minute, should states be able to choose that they're going to have slavery? Well, of course not. We solved that one by the 13th Amendment.
Correct.
We took that away.
Yes.
And that's the way that you remove state power, through a constitutional amendment that is clear in its words. I mean, look. And
the whole society, though, by assenting to that and by ratifying it, agrees.
And the founders really intended that, and Justice Story made this clear, that the Constitution is to be read in a common sense sort of way.
Yes.
It was not magical language.
Right.
And for example, the phrase that's been the largest weapon, if you will, for the Supreme Court to suppress state power is what's called the Due Process Clause in the 14th Amendment. What it says is, and I'm going to paraphrase it, that no state...
Because we're down to 2.5 minutes.
Well, that's okay. No state shall enact or enforce a law that would remove a person's life, liberty, or property without due process of law.
Right.
Well, you could ask a second grader what that means, and the answer would be, well, it means you can't take someone's life, put them in prison, or fine them without a fair trial.
Right.
And it comes right out of the Magna Carta.
Yes.
And they wanted to put that principle into federal prosecutions. Where in those words does it give a woman a right to an abortion? Right. Where in those words does it limit the states in defining marriage?
Right. Yeah.
There's no common sense understanding of that. Right. They're just pretending that these are sort of magical words that can lead to any number of interpretations.
Yeah. There's two things that Kathy and I always talk about that, common sense and common courtesy are no longer common any longer. So when you take that into consideration of all things. Dave, give us a kind of a last 30, 45 second wrap about your book or yourself or whatever you want to get across in this last minute and a half of the program.
I mean, again, the purpose of the book was to explain to people the history of the Constitution, which leads one then to an understanding of what the Constitution meant. It's fundamental to the society that we have, that we did something in 1787 that was so radically different from what existed in Europe. And the men who created this new political system, again, were very bright men. And they put together a good system that's embodied in the state constitutions, which we all forget about, and our federal constitution. And it's my belief that we ought to follow the law. And if we don't like the law, then we change it in a manner that the law provides for it.
Yes. Yes.
But not give that power to 5 lawyers.
Yes. Yeah. No, absolutely. Now, again, ladies and gentlemen, I'll tell you, Dave, has just been a delight to have you on the program. It's been really exciting for me to have this opportunity to really sit down. And remember, folks, it is UnFaithful Guardians. The book is available at Dave's website, and that's on the link. Dave, real quick, what's the website?
UnFaithfulGuardians.com.
There you go, ladies and gentlemen, and come on back next week when we're going to have John Trudell on here as Samuel Adams will return, and those anti-federalists, they absolutely got it right.